The Supreme Court just heard a case that could restore Second Amendment rights to millions of Americans, or restrict them further. If you own a firearm, use marijuana, or carry a concealed weapon, this directly impacts you. Before we dive in, make sure you're subscribed. I'm covering a live Supreme Court case argued just days ago that could transform federal gun law overnight. Hit that subscribe button now. Why? Because most gun owners miss critical legal updates, and I don't want you caught off guard. Here's what happened. On March 2nd, 2026, the United States Supreme Court heard oral arguments in United States versus Hamdani. Remember that name. It could become one of the most significant cases in Second Amendment history. The justices examined a federal statute that makes it a felony, not a misdemeanor, a felony, for certain users to possess firearms. We're talking about up to 10 years in federal prison simply for owning a gun while using marijuana, even in states where it's legal. Here's what the media isn't emphasizing. This isn't some forgotten obscure law. It's the same statute used to prosecute a former president's son. You likely heard about the Hunter Biden gun case. That prosecution relied on this exact law. Now the Supreme Court is determining whether that law is constitutional at all. Let me explain. There's a federal statute, 18 U.S.C. paragraph 922G and 3. That's the technical citation. What it means is simple. If the federal government classifies you as an unlawful user of controlled substances, possessing a firearm becomes a federal crime. Period. It doesn't matter if your record is clean. It doesn't matter if you reside in Colorado or California, where state law permits marijuana use. Under federal law, marijuana users are prohibited from gun ownership. Violate this, and you face up to a decade in federal prison. Now, here's where it gets compelling. A man named Ali Daniel Hamdani was charged under this provision. He used marijuana. He owned firearms. Federal prosecutors deemed him a criminal, but his attorneys challenged the charge. They argued this statute violates the Second Amendment, the right to keep and bear arms. Here's the remarkable part. The Fifth Circuit Court of Appeals, just below the Supreme Court, agreed with him. They invalidated the law, ruling that marijuana use alone cannot strip someone of their gun rights. The government appealed. They escalated to the Supreme Court. Now 9 justices will issue the final word. Most observers assume the court will side with the government and affirm that drug users forfeit gun rights. But that's not what transpired during oral arguments. According to legal reporters present, the justices appeared skeptical of the government's position. They questioned whether this law overreaches. Several noted its excessive breadth. It equates occasional marijuana users with daily heroin addicts. That distinction matters, and the court seemed to recognize it. Back to Hamdani. Why this matters personally. Currently, approximately 50 million Americans use marijuana in some capacity. Many are also gun owners. Under existing federal law, every one of them technically commits a federal crime daily. Consider that. 50 million people, most unaware they're violating federal law because their state permitted marijuana use and firearm ownership. Here's a realistic scenario. You live where marijuana is legal. You consume it occasionally on weekends. You maintain a firearm for home defense. No arrests, no violence. You're a responsible, law-abiding citizen by state standards. Yet, under the federal statute currently under review, you could theoretically face federal felony charges merely for keeping that gun in your residence. That's what's at stake. Here's the contradiction. The same government arguing before the Supreme Court that marijuana users should lose gun rights has simultaneously permitted legalization across half the nation. This inconsistency didn't escape the justices. Some directly challenged government attorneys on this point. They asked, how can the government deem someone dangerous and strip their rights for using a substance legal in their home state? The government's response was essentially this: even if legal locally, marijuana remains federally prohibited. Historically, Congress possessed authority to disarm individuals it considered dangerous. But here's the crucial question the court faces. Is an occasional marijuana user genuinely dangerous? Does moderate use render someone so unreliable that they should permanently lose a fundamental constitutional right? This brings us to the Bruen decision from 2022. You need to understand Bruen because it underpins nearly every Second Amendment case currently. In 2022, the Supreme Court ruled that for any gun law to stand, The government must demonstrate a historical tradition of comparable regulations dating to the founding era. That's the history and tradition test. This standard has created turmoil in lower courts because it's difficult to locate 1790s-era laws regarding marijuana users and firearms, for obvious reasons. The government struggles to prove historical tradition. They cannot easily show that founders routinely disarmed drug users because, frankly, the founders didn't have the DEA. They didn't have Schedule I substances. We're testing modern legal concepts against 18th century standards, which makes this case explosive. 73% of viewers aren't subscribed. Don't join that group. Join thousands of gun owners receiving these legal updates first. Hit that subscribe button. But Hamdani isn't the only major case. Another significant decision pending before the Supreme Court affects everyday gun owners nationwide. It's called Wolford v. Lopez, argued January 20th, 2026. Here's what Wolford addresses. Several states, including Hawaii and New York, enacted laws stating that concealed carry permit holders still face restrictions. Even with a permit, you cannot bring your firearm into restaurants, grocery stores, shopping malls, or other private businesses open to the public unless the business posts a sign explicitly welcoming firearms. The default position is no guns allowed. You must obtain permission from every private business before carrying on their premises. Consider the practical implications. You hold a valid concealed carry permit. You earned it. You passed background checks, completed safety courses, paid fees. You followed every rule. Yet, every time you carry for self-defense while running errands, you must verify whether each store posts a "Guns Welcome" sign. No sign, and you enter carrying anyway? That's a criminal offense. Here's the encouraging news. Supreme Court justices hearing this case appeared sympathetic to the gun owners challenging these laws. Multiple justices questioned how this default prohibition aligns with the constitutional right to carry firearms for self-defense. A ruling is expected by June 2026, just months away. This decision won't only affect Hawaii, it will signal to every state how far they can restrict where permit holders may carry. If the court rules against Hawaii, states like New York with similar laws must change their rules. Millions of permit holders nationwide could see their carry rights significantly expanded. Currently, the Supreme Court is in a historic period for Second Amendment jurisprudence. They're deciding major cases in the same term, whether marijuana users can own guns, and whether states can effectively ban concealed carry in most private businesses. These aren't minor technical questions. They're monumental decisions affecting tens of millions of Americans. Here's what you should remember. First, if you use marijuana and own firearms, the federal government currently considers that illegal. Second, if you hold a concealed carry permit in certain states, understand your state's restrictions carefully. Third, the Supreme Court appears inclined toward protecting gun owners in both cases, but appearing inclined isn't ruling. Until the decisions arrive, current law still applies. We'll track Hamdani and Wolford closely as the Supreme Court approaches final decisions. Stay informed, stay legal, and I'll see you in the next video.